The provincial government really does not want the public to read the cabinet mandate letters written in 2018 by the then newly elected government led by Doug Ford. Last week, we found out their case will go before the highest court in the land. With us to explain what's going on, from the beaches in Ontario's capital city, there's James Turk, director of the Centre for Free Expression at the former Ryerson University, now called Toronto Metropolitan University. James, good to see you again. How are you managing?
I'm fine, thanks. Nice to be with you, Steve.
A pleasure to have you. Just for those who are coming to this story new, what's a mandate letter?
A mandate letter is directions that a premier or a prime minister gives to each member of his or her cabinet as to their priorities in the coming year.
Now, recently, and by that I mean Kathleen Wynne in the previous Ontario government and Justin Trudeau in the current federal government, have released their mandate letters, their marching orders to the cabinet ministers. Doug Ford has chosen not to. Do you know why?
I don't. It's puzzling. One would think, as Kathleen Wynne and Justin Trudeau felt, that you want the public to know what the government's priorities are in each of its for each of its ministers, and they proudly trumpet them. So all of us were a bit taken aback in 2018 after Doug Ford was elected, when the CBC's request for access to the mandate letters was refused by Cabinet Office as a violation of Cabinet confidentiality.
Now, having said that, there is no law or legal obligation that requires them to do that, right?
No, but all governments, and Doug Ford is quoted repeatedly as saying that he's a strong believer in transparency. As a value in Canada, we want our governments to be transparent so the public can be informed and can exercise its proper democratic oversight of what governments do. So there's every reason to release them, although there's no obligation to do so.
I know you're not a lawyer, but is it reasonable to argue, as they are, that mandate letters are all part of cabinet confidentiality? We don't release what ministers say about various topics at the cabinet table, and this is merely an extension of that.
That is the argument the Ontario government is making, and it's an argument that I think is wrong, but it's also an argument that the Information Privacy Commissioner of Ontario felt was wrong. It was an argument that the divisional court that reviewed the Information Privacy Commissioner's decision felt was wrong, and it's the decision that the Ontario Court of Appeal felt was wrong.
Now, what in particular concerns you about, I know you don't know the reasons why they're refusing to make these letters public, but what potentially concerns you about why they might not be making these public?
My concern is less what might be hidden in the particular documents and more, I think that we have a government that really doesn't believe in transparency and is using the exception for cabinet confidentiality to include a lot of things that are not properly part of cabinet confidentiality. I mean, if I could just explain, it is important for members of cabinet to be able to freewheel, to discuss ideas, to try out, proposals, to respond in different ways, and not to be held publicly accountable for what they may say in these brainstorming sessions. So that there's a proper protection for cabinet confidentiality for that process, but not for the outcomes of it. What's protected in the law, Section 12.1 of the Act, says that they're not to release records that disclose the substance of deliberations in cabinet. A transcript of what was said in cabinet, for example, could never be disclosed. But mandate letters are not that. Mandate letters, according to the testimony in the court trials, didn't even go to cabinet, much less reveal the deliberations that took place in cabinet.
Now, give us some of the legal history here. Why is this before the Supreme Court of Canada now?
Well, when the government of Ontario refused to give these to the CBC has a right to appeal a decision under the Access to Information legislation to the Information and Privacy Commissioner. And in this case, rather than one of the staff of the commission writing the response, it was the commissioner himself, and he directed the government to turn it over. The government appealed this, went to judicial review in the Ontario Divisional Court, and the judges in that case decided that no, the Information Privacy Commissioner was correct. It had to be turned over. So the Ontario government appealed it to the Ontario Court of Appeal. And the Ontario Court of Appeal, in a majority decision, decided no, the letters did have to be turned over. So now the Ontario government sought its last option, which was to seek leave to appeal to the Supreme Court, which was granted, and now it's before the Supreme Court.
So if you're keeping score at home, the Ford government has never won at any level in the court system. Is that right?
That's absolutely correct.
Now, okay, I admit this next question is going to be laden with a lot of hypotheticals here, but so get comfortable and hear me out. Right. If the Supreme Court's going to hear this case, by the time they hear this case, and by the time they decide on this case, the election's going to be over. And there will be a new cabinet installed, regardless of whether it's a progressive conservative cabinet or another party which wins the next election. All of which is to say, by the time these mandate letters ever do get revealed, if that's what the Supreme Court says, there's another if, these ministers aren't going to be the ministers of whatever they were the ministers of before, and this is all going to be pretty much, well, you tell me, irrelevant at that point or what?
Well, in terms of what was in those original mandate letters and their importance, it's probably irrelevant now. I think this is being fought for a bigger reason, and that is transparency, the public's right to information is something that all parties in opposition think is great. When they come to government, when they become government, suddenly they're not so sure that secrecy doesn't have its merits. And so I think what's at stake here is something very serious for the public. If the Supreme Court were to decide that the Ford government is correct, and the argument is that cabinet secrecy is like a big black hole, and anything that comes near the cabinet can be withheld from the public, then that will be a significant reduction in the amount of material to which the public has a rightful access. So lots at stake here, not so much about what was the content of those letters, but how expansive the notion of cabinet confidentiality is. So any document that may have gone to cabinet, any document resulting from cabinet discussions without revealing those discussions, or any document or policy that might in future come to cabinet could be excluded from being released to the public. And it's hard to understand how a democracy can be as vibrant and robust as it should be with that degree of secrecy permitted.
And just finally, if the Supreme Court, here we go hypothetical again, if the Supreme Court decides in the way you would like it to decide and against the government of Ontario, that means they're going to have to make the letters public because there's no more appeals after that. Are you concerned at the end of the day this is going to be, as we call it in the business, a big nothing burger, and you'll be sitting there scratching your head saying, what the heck were they so concerned about? There's nothing here that's worth keeping secret anyway.
Well, I guess I've increasingly come to the view by their persistence that this isn't really about mandate letters. It's about how expansive the notion of cabinet secrecy and how much generally can be withheld from the public as a result of this exemption for cabinet secrecy. Is it the narrow vision of cabinet secrecy pertaining only to the deliberations of cabinet that is to be protected, as I think it should be protected? Or is it anything that comes anywhere near cabinet that can be excluded, which allows governments to hide all sorts of things that should be properly disclosed?
Gotcha. Jim, you better go take that call because we're out of time anyway. It's good of you to join us on TVO tonight. Thanks so much.
My pleasure, Steve. Bye-bye.
That's James Turk from Toronto Metropolitan University.
The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.